Your Honor, this is one of the co-defendants from the video that you've seen multiple times now from the gas station.
All right, 23 CR 1656 is called Carl Chopin. Mr. Himmler, this was filed in the 252nd District Court, but I think we put it in the right court here.
I filed it under the cause number, so it should have a separate writ number.
Yeah.
This is a writ.
I see a petition for writ.
Correct.
Right.
So it'll have a writ number and probably is assigned in this court.
CR 1656, which is this.
That's the cause number, not the writ. In other words, when it's processed, it'll have a writ number attached to it, not the cause number.
It says, I see something January 24th. You sent to Judge West. Please advise I'm representing. I will be filing a writ for bond reduction. Is that for this case?
That's correct.
What's the bond in this case?
$250,000.
Okay, go ahead.
Your Honor, the court can review the indictment. First of all, you'll see that there's no enhancement allegations in the indictment. This is a serious bodily injury assault case without, as I said, enhancement allegations. So it's basically a non-aggravated second-degree felony case. The bond is set at $250,000. And just to be clear, I'm assuming that the court has granted the application for the writ, and we're here to determine. We're conducting a writ hearing.
The court always opens the door for consideration of bond issues.
Right, but in the context of the case before the court, we're here on a writ of habeas corpus, an application for a writ of habeas corpus. I'm assuming since we're having the hearing that the court has granted the application for the writ, and now we're proceeding to determine whether the relief.
Well, okay. Whenever you become that wordy, why wasn't a motion for bond reduction filed?
Because a writ of habeas corpus is the proper way to address bond issues. And actually, there's an interlocutory appeal from a writ as opposed to a motion, which it would be. Yeah,
now we'll begin to the part of the matter. Right. But at the end of the day, it's the court looks at it seriously and under the rules of law. It's the same. So go ahead.
Well, Your Honor, the purpose and the reason, if you'll bear with me for a second, the reason for that is if the court is not clear on whether the writ has been granted or not in this context, the appellate remedy is mandamus, not an interlocutory appeal. So I just want to make sure that what we're talking about is whether the relief in the writ is going to be granted or not. Thus, an appeal would be proper, not that the court refused to grant the actual application for writ of habeas corpus.
Number one. Okay. Once again, sometimes when we want to try to read things into the law, there is it loses the practical method of why it's all about, and why it's written and what it's there for. Right now, upon what you sent, I produced the man right here, which is what you've asked for.
Right.
Okay, all of that word, it speaks for itself. He's standing right there.
So the application.
So issue a writ and require to produce the body. I have done that. Okay, what's next?
So we're proceeding on the relief requested.
God bless you. Yeah. How else can he be here unless he walked from the jail or was escapee? And come on, let's be practical.
I've had this issue come up.
He's right here in front of the court by your application for writ. I produced him.
Your Honor, at this time, if the court's prepared to hear evidence on the relief requested in the writ, I could call it Takesha Gilbo.
Go ahead.
Ms. Gilbo. And she has not been sworn. Come up over here. Stand back here. Stand away from.
Raise your right hand. You solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth. So help you God. Lower your hand.
Go
ahead.
Well, I'm going to do that. Would you state your full name?
Akira Gilbo.
And would you spell set your full name? What is your full name?
Akira
Deny. Spell your name.
Cykeria. JANIAHGILBEAU.
Ms. Gilbo, how old are you? 20 years old? Where do you live?
In Baytown.
Do you know the defendant Carl Chopin?
Yes, sir.
How do you know Mr. Chopin?
Yes, sir.
Boyfriend, is that right? In connection with this hearing today, I asked you to collect some information.
Yes, sir.
Did you, in connection with that, contact 3 separate bonding companies licensed in Jefferson County?
Yes, sir.
And did you inquire as to each of those bonding companies, what they would require as far as payment for a $250,000 bond in this particular case?
Yes, sir.
Which 3 bonding companies did you contact?
Bell America, Alvin, and Ella.
And as far as each of those companies, did you also not only ask what they would require for a $250,000 bond, but for a $100,000 bond and for a $50,000?
Yes, sir.
As far as Bail America, what did they tell you as far as the bonding requirements, financing, payments, co-signers, that type of information for those 3 bonding amounts in this particular case? What would they require?
Bell America offered for the 250, like the regular bond, they offered 10% of the bond, and they wanted 4 co-signers with 8 monitors. And for the 100,000,
How much were they required down on the $250,000? Of the $25,000, how much did they want actually paid up front?
10,000.
$10,000. Okay, what about the $100,000?
Well, wait, $100,000 bond are we talking?
This is.
All I have is 23 CR 1656. That's all I have before me.
This is to show his ability to make a bond in a reduced amount. or
Okay,
inability-
I only have this aggravated assault in front of this court, right?
Correct, and the bond in that case is $250,000. As part of the proof necessary, I have to demonstrate that he can't make bonds even in a reduced amount to establish what would be a reasonable bond. That's why I'm inquiring as to the financing and requirements on lesser bonds of 100,000 and also 50,000 in addition to the bond as it's presently set at 250,000. Which I think is a requirement to prove.
Go ahead.
Okay, I'm sorry, Your Honor.
Go on. We'll be here all day. Let's go. I'm not stopping you. I'll forward.
All right, so what did they say on the $100,000 bond, Bail America, the financing and the requirements?
For 100,000, they just offered 5,000. Sure, go back.
100,000?
Yes, sir.
What was the total amount of the bond that they wanted on?
It was 10,000, or they took 10,000, they really want 500.
Up front,
Yes, sir.
you still have to pay the other 5,000.
Yes,
Payment, monthly payments?
sir.
What about a $50,000?
The 50,000, they offered 5,000, they reduced to 5,000, and they want 30,000 as bonuses.
And then finance the rest of that, is that correct?
Each month.
And with all of those bond amounts, they would also require a GPS monitoring device to be installed
Yes, sir.
on their own, even without a court order, is that right?
Yes, sir.
And they wanted four co-signers with each bond, is that right?
Yes, sir.
Or was that just with the $250,000
It's all three.
for all 3? What about Al Reed? What did that bonding company do? Mr. Al Reed, Bill, what did they tell you as far as the $250,000?
For the 250,000, it was the same for the building. They just wanted to do the team. And we put one thing.
Up front? What about a GPS device? Did they require that
You know, so they just. need the team.
up front?
Yes, sir.
And then finance the balance of that, the 15,000?
Yes, sir.
So they just want 10,000 up front?
Yeah,
How many co-signers did they?
for
What about for a $100,000? What did Al Reed require?
100, they just reduced it to 10, they just wanted 5 more. Up front, 5,000 up front.
And then 5,000 finance?
Yes, sir.
Let me be clear on the $250,000 bond with Al Reed. They wanted 10,000 up front, and you had to finance 15,000.
Yes, sir.
That's what I thought. So what about the $50,000 bond with Al Reed? I mean, I'm sorry, yeah, 50,000. What did they require?
They just wanted 1,500 for 50,000.
Down,
Yes, sir.
and then how much was the total amount for the bond?
5.
And they would allow you to pay the balance of the, what would that be, 3,500?
Yes, sir.
How many co-signers did they?
2.
What about, what was the third one, professional or allied? Allied.
Allied.
Allied. So what did Allied Bill bonds tell you regarding the $250,000?
They just wanted 10%, so $10,000.
Well, did they want 25,000 total and 10,000 down?
Yes, sir.
So they would finance 15,000.
Yes, sir.
How many co-signers did they require?
So,
And did they require a GPS device?
yes, sir.
What about for a $100,000 bond?
It's the same, we wanted 10%.
So $10,000, how much would they take down in finance? And what about a 50,000?
30,000.
3,000 down,
Yes,
and then finance.
sir.
Now, are you familiar with Mr. Chopin's finances?
Yes, sir.
How long have you known him?
3 years.
3 years? Do you know if he has any savings accounts or money invested in stocks and bonds, mutual funds, ETFs, any type of investment, anything like that?
Yes, sir.
What is it? What are his finances, to your knowledge?
He has a bank account.
You know what the balance is in the account? Other than a bank account, which you know what bank it is? Other than that, do you know if he has any real estate, any investments, any cars, anything about? Pass with us.
Right, so you stated you've known Mr. Chopin for 3 years.
Yes, sir.
Were you aware that he was charged with and ultimately convicted of burglary of a building that occurred on January 6, 2021,
Yes, sir.
and that he was placed on probation for that offense?
Yes, sir.
So you were with him during that time frame.
Yes, sir.
And so you must also be aware that he was, a motion to revoke probation was filed on him in April of 2022. And that he was sentenced on that to 12 months in the state jail. And you stayed with him through that entire relationship.
When was he sentenced?
First off, ma'am, do you know that answer? What the judge just asked?
Specifically, June.
I told you it was June 22nd, 2022. That sound right? And again, you're here saying you've known this man for the last 3-4 years. You remember that? Okay.
Your Honor, I believe I'm going to object to the state characterizing it as 3 or 4. I believe her testimony was 3. Inaccuracy to the record. She testified she was in
The record will speak for itself. Go ahead, ask your next question.
Do you remember that when his sentence expired on that burglary of a building, when he got out of state jail? I represent to you that it was March 5th, 2023. Would you agree with that? Is that a yes? All right, so basically, so right now we're in February of 24. So about 11 months ago, he got released from state jail from that 1-year sentence he received. Right?
Yes, sir.
Now, were you with him on October 1st of 2023?
Yes, sir.
You're aware that of the situation that he's accused of beating an individual by the name of DeLorean Jefferson at that gas station along with some 8 other defendants. Now, I want to make sure, were you with him on this occasion, ma'am? I mean, actually at the gas station? Okay. Did any of those bonding companies that Mr. Kimmler just talked with you about, did they mention either one of those facts in assessing the amount that they wanted for these bonds? Specifically, we'll deal with it, we'll break it down. Did they talk about how he had the prior state jail felony conviction? Did they talk about, the second thing, did they talk about the notoriety of this particular offense? So they didn't mention either one of those things to you. That's what it is.
Nothing further.
All right, next.
Alicia Chopin. She has been sworn.
Let me show him. Okay, you ready? Raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Sure.
Go ahead.
Would you state your full name and spell your full name?
Felicia Nicole Champagne, FBLE, Nicole NICOLE, Champagne, CHOPANE.
Ms. Chopin, I'm gonna go ahead and ask you this in anticipation of your hand asking you this. You ever been convicted of a felony in this jurisdiction? You ever been convicted of a misdemeanor crime of moral turpitude such as theft or false report to a peace officer or anything like that?
Mostly,
Where do you live or reside?
Hampshire, Texas. Hampshire, Texas.
And which county is that in?
Yep,
And how are you related to Carl Chopin?
that's my son,
Biological son?
my stepson.
Stepson. Did you rear him from a child?
Yes, sir.
From what age did
8
you?
years old.
From 8 years forward, is that right?
Yes, sir.
Where was he reared? What county?
Jefferson County.
What high school did he graduate from, if any?
He was in Ozan, but graduated early. Evolution Academy.
And that is in Jefferson County? So he has been a resident of Jefferson County up until the time he graduated from high school, is that correct?
Correct.
At some point, did he move to Baytown?
Yes, sir.
When did he move to Baytown?
So it might not even been quite 2 years yet, maybe a year or 2 years.
Between a year and 2 years
Yes,
ago.
sir.
And Baytown is in Harris County, Texas, is that correct?
Correct.
Since he moved to Baytown, have you maintained contact with him? Speak with him, is that right? Do you know if he's related to anyone in Baytown, or what was the reason that he moved to Baytown, Harris County?
His girlfriend, and he had got a job there.
Where was he working in Baytown?
It's a grocery store, a couple of miles on Main Street. I don't remember the name of it.
And to your knowledge, he's gainfully employed or was gainfully employed in Baytown, is that correct?
Correct.
Before going to jail, is that right? What other family members does he have in Jefferson County besides yourself?
My husband, his grandmother.
So would you agree with me that he has substantial ties to Jefferson County?
Probation.
Would you be willing to act, you heard, Ms. Gilbo reference a co-signer on a bond, would you be willing to co-sign a bond and be responsible for his appearance in court?
Yes, sir, that's my son.
Last witness.
Ma'am, you've heard the questions I asked the other witness, did you not? You were paying attention, not working.
Yes, sir.
So when I represent to the court that this man was on probation for an offense from January of 2021, you were familiar with that, right?
Correct.
That he was in fact sentenced to a year state jail. And that was approximately in June of 2022.
Correct.
And he was in custody all the way up until March of 2023.
Yes.
So this offense that we're dealing with is roughly 7 months after he gets released from custody. When I know you stated something to the judge about his employment. When did he get that job? Where in that time frame did he get that job?
I don't actually know dates, but he worked there for several months. That didn't hear yet, but it was several months.
So was he working in Baytown before this offense occurs here in Jefferson County?
Yes, sir.
Do you know why he was back in Jefferson County if he was working in Baytown on that particular date?
He had an off night and came to visit me and was at the store to get ice cream. And that's why he was at that store.
Were you there?
No, sir, I wasn't.
Have you seen the video?
Yes, sir, I did.
All right, nothing further.
Just briefly, are you familiar with his finances?
Yes, sir. Well, before, the job, he was working the job. But here recently, I have an account for him.
How much money is in your account? Is that your account for him, or is that?
I opened it up a while back.
How much money is in that account?
$500.
Other than that $500, does he have any financial resources?
Well, he's not employed at this time, but no, sir.
Does he own his own vehicle, own his own car? Does he own any other real property like a boat or a trailer or a motorhome? Anything of value that he can own?
No, sir.
Does he own any real estate, any houses, any property, anything like that?
No, sir.
Does he own any investment income, stocks, bonds, mutual? So the only money that you're aware that he actually has disposed to pay for a bond is $500. Is that correct?
That's just what's in favor. If there had to be,
How much-
he's responsible for it.
Do you know how much money he has available to pay for a bond other than that $500?
With the help of myself and his dad, we will, but yes, he only has the 500.
Presently, the bond is amount of $250,000. You've heard Ms. Gilbert attest about that. The resources available to Mr. Chopin, are you available to, would you be able to post that bond?
Yes, sir, he would be.
Now
Well, we
$250,000.
were asking for some help, for it to be, reduced.
So you can't post the bond in the present
Not
amount.
$250,000.
That's what I'm asking you. You can't afford to post a bond in that amount, is that
No,
right?
sir,
And he can.
no, sir.
What about 50,000? Could you afford that bond based upon what Ms. Gilbo found out from the bonds and what would be required down payments and finance?
Yes, sir.
Would a bond in that amount, in your opinion, reasonably assure his appearance for trial to contest this case, like this case, and go with it?
Yes, sir.
What about a bond in the amount of $100,000? For trying to raise the money necessary to post that bond, and you've been successful at that?
Yes, sir, yes.
You've tried,
We will be able to try to.
but as it stands now, could you post a bond in that amount, $100,000? That's what it's Rick does.
No further questions, Sheriff.
You can sit down. Your Honor, I think, that's all I have, I can, except for arguing.
All right, anything else from the state?
No, Your Honor.
All right,
I mean, I do have argument.
before you argue, Court has something else to add, from the file here. Thank you. The defendant, was brought up. The defendant had, even though it's not part of the indictment, was brought up that the defendant had been previously convicted of burglary of a building. And the court's files, the records in this case, it's cause number 234712. And in that case, which was presided over by Judge West next door in the 252nd District Court, the defendant was placed on deferred or unadjudicated probation for burglary of a building on January of 2021. He reported 1 month and then absconded. And he was pleaded true to failing to report to the probation office since on or about February 1st of 2021. Again, he was placed on probation January 6th. Within a month, he was absconded after his first report. He also pleaded true to providing a urine sample on or about February 4th. On that day, he last reported that showed the presence of tetrahydrocannabinol. Both the court found there were violations of his conditions of probation. And in the bail factors that we look at under Article 17.15, the nature of the offense and the circumstances under which are committed are to be considered, as well as whether the offense involved a crime of violence. Other bail factors include whether the defendant has previously complied with bond conditions, any aggravating factors in the charge. The thing that bothers this court, other than the circumstances of this case, which are quite disturbing, and that is he absconded from probation within a month and was caught using illegal drugs. And I'm waiting for information from the probation office to see how long he had absconded until he was arrested. I don't know that. I want to know when he was arrested after he absconds on his court-ordered probation. The point being, if he can't follow those rules, he's certainly not going to be treated favorably under the bond factors. He has failed the previous test royally on reporting responsibly, following the rules not to commit other crimes. Illegal use of drugs is a crime. And admitted to those. Also failed to provide verification of any community service hours that were required. If he can't follow those, I want your argument to address the issue here. What is it a bond condition is going to do when threatening to put him in a prison facility for violations didn't stir him to follow rules? Go ahead.
Your Honor, I think that I'd have to look at the motion to revoke, but of course, failing to report.
There it is.
Failing to report.
After 1 month and absconding.
Yeah. I want to say it was just the number of times that he failed to report, it's never reported. It appears that he didn't ever report to probation. I would just state to the court that that's a state jail felony case. Obviously, it's a felony in serious, you go to state jail for 2 years. What he's facing now is 2 to 20 in the penitentiary with a bond that I'm sure, even if it's not $200,000, will be significant enough that should he fail to appear, he would be putting the co-signers at risk on that bond who are going to have to co-sign for him, which I assume is going to be his stepmother and other family members, that he would put them to be responsible for the amount of the bond forfeiture if he doesn't appear for court. To have that responsibility.
Why would he care about them when he didn't care about himself and his own freedoms here in this probation that he was just on?
I could just relate to the court that it's been my experience when there are some people who have the responsibility not only for themselves, but know that their family members can be responsible for a substantial amount of these bonding fees. That does tend to be an incentive for them to show up to court. It also incentivizes the co-signers, should there be a bond forfeiture, to work with the bond agent to make sure that he's returned to custody, that there's a way to get him back into custody. That's the reason they require co-signers.
So you're saying, wait. So you're saying that not following conditions of probation from the beginning and knowing that would certainly, as an absconder, likely lead to revocation of probation and confinement for a felony and a conviction of felony, you're saying that doesn't bother your family?
What I'm saying is, Your Honor,
no, it does. So it's the same argument. He knows he hurts his family when he does something like that.
Perhaps. I would also add, Your Honor, that should the defendant fail to appear in court, there's an additional charge of bond jumping that would be available to the state. It would be a fairly easy case to prove. That's one level above, I believe, what the charged offense is. So thus he would be facing a consecutive first-degree penalty range, potential.
He did it. Argue this. He's already absconded before. Why wouldn't he do it this time?
Because the stakes are so much higher here than on a state jail felony case.
Oh, it's just a matter of the degree of stakes?
I think if a person understands that if they fail to appear for court, they could be charged with a first-degree felony. That's 5 to 99 to life. It could actually be stacked. The time could actually be stacked on the second-degree case. But that would tend to incentivize them, but not to miss court.
But you're saying it doesn't have anything to do with the fact that it's right versus wrong, and it has its loss. failing to follow the bond conditions.
I agree that that.
All right, well,
that-
but he's already shown he doesn't care much about the rules before, the same kinds of rules.
I would just
Why
say
would there be a difference now?
contextually that this is different because the stakes are so much higher. There's a different context here. But also, as the court is aware, this probably is not going to be a probation offer from the state. Anticipating Mr. Ham's offer on this. If Mr. Chopin wants to avail himself of a jury trial or even pleading the case guilty to a jury, he's going to be in pretrial detention for a substantial amount of time, as many other people are. And that's another consideration I'd ask the court just to be aware of is the length of pretrial detention, that if we refuse the state's offer, we want to plead the case to a jury or go to trial on it, that there's going to be substantial length of pretrial detention that the court could address. In this case, by allowing him to post bond and requiring him to have a GPS. In other counties, if we had a pretrial services department, which we don't, he could actually be ordered to report regularly to a pretrial services officer.
You mean like he failed to do when he was on bond,
Again,
when he was on
if he-
probation
if he-
before?
If he
No,
fails.
no, no, let's,
Well,
like he failed to do before, you're not changing those facts. To me, that was a serious situation. And I mean, 1 month and he was gone.
I can't change.
He didn't care about the rules. He knew what was responsible here. He might lose his bond. He had more at stake.
I can't change the past. John.
I know you
It
can't
is- it
change
is what it is, and obviously the court can consider
And
it. I'm just saying that
But the past are facts. You're hypothesizing.
Well,
The facts show he is frivolous in following the rules.
certainly the best indication of future behavior is past behavior, but obviously people learn from their mistakes and can make changes. And I would just simply argue the court, a bond in the amount of $250,000 is excessive. I mean, the court can provide the incentive necessary for him to be in court to deal with this case with a bond and a lower amount. If
You
the
make-
court would make some kind of, I mean, there are people in jail that are on bond for substantially less that are charged with murder.
Okay.
in this case.
Anything else?
No, sir.
The court, his bond is $250,000 now. I'll reduce it to $200,000 in the following conditions. He must have home confinement. He must have a GPS device. He must have a drug patch. There will be other terms and conditions of probation that this court may also address if and when he is able to produce that. But the problem he has is his history and his track record. He was on probation in cause number 234712 for a burglary of a building, reported 1 month, then absconded. I don't have the exact date when he was, does probation know on this case what the date was that he was taken back into custody on that? That's all.
They're sending someone to answer those questions for you, Judge.
You could probably pull that up.
No, I can't, no, we can't. We have the motion and when it was filed on April 12th of 2022.
When were you taken into custody? When? May 14th,
Of what year?
2022.
Yeah, he has absconded a year and a half. He absconded almost a year and a half. And you always fight valiantly. Here, this isn't a good set of facts to show that he can follow rules. No, you didn't. You royally failed. And the one thing you have to do is report. And that's key to a bond condition. And you made F minus. Very few people on my watch abscond from after a month of probation. And then we're involved here with, and not only that, but also failing to follow the rules by failing the drug test. He has drugs in his system a month into his probation. So those are the two main issues for probationers, not committing crimes and reporting. And he blew those away royally. Then he's charged here with this aggravated assault with a deadly weapon. This court has seen and has dealt with the hearings on this matter. And the circumstances of that are terrible. And that's under Article 17.15, rules for setting amounts of bond. The nature of the offense and the circumstance which it's committed are to be considered, as well as whether the offense involves violence. Here, whether bond factors are included, such as whether the bail factors are to be considered, whether he has previously complied with bond conditions, and this court would say that probation terms are twins to bond conditions set, since they work in the same manner. That is, there are ramifications to the defendant's liberty if he fails on bond conditions. But here, when you're on probation, after you have been admitted guilt of a crime, and then you frivolously mishandle your responsibilities of reporting and obeying the law, that proves that the defendant is a risk to the community. And I've seen, again, back to the circumstances in this offense, this is an offense that occurs at 3 o'clock in the morning, where a group of people have essentially taken over the convenience store, where no one, the group of people were so large, no one who wanted fuel, who was running out of gas at 3 in the morning, could get fuel, because all the pumps were taken over by vehicles that were there for a party atmosphere. It had nothing to do with buying merchandise. If someone needed milk for a child, the only stores that are open really are convenience stores. And it was packed. Somebody could not safely navigate through this crowd to get into a convenience store, and they wouldn't want to. They'd be intimidated. A mob had taken over a business, and this city, as far as that area was concerned, was essentially shut down for anybody to be safe in. And then the beating of this man, who was put in a coma type condition, occurs, and this defendant is charged with his involvement, according to grand jury, aggravated assault with the use of a deadly weapon, namely a firearm. All of those reasons point to the fact that this defendant does not fit under the rules leniency in consideration of bond. And the rules and the law that I've described and the circumstances that this court has enunciated are in the record, and those are the rules set forth for the bond in this case.
Yeah,
That
can I clarify one? You said home detention, do you mean home Baytown or home Jefferson County? What is home?
the last place he was indicted by, his home was supposed to be 3400 Veteran Circle, apartment 404, Beaumont.
Oh, so that's home? Just to be
That's
clear.
what the indictment says.
If that changes, then they ought to make mine if the court would grant me latitude to determine residence.
You bring it up to me, and then we'll take that step when we need to. Anything else? That's all. Monica Haynes,
Yes.
what's your criminal history?
She has extensive,
Well,
not
nothing.
any. There's
Oh,
not any
okay.
serious
So
felony.
she's eligible for probation.
She is.
Okay.
She says she would take probation.
You are Monica
But
Haynes.
somebody-
I'm sorry. We had another Haynes. You're Monica Jenkins.
I'm Monica Jenkins Haynes. In jail, they had me, they used all my names, my mom's name, Okay.
Okay, yeah. Well, on 41528, the indictment states Monica Monique Jenkins.
Yes, sir.
That's you, though.
That's we,
Okay, and then 23 CR 2003. Then 2002, the numeric sequence. You are charged as Monica Jenkins Haynes, and that's you as well.
Yes, yes, yes.
Okay, now. Let's go over this mess here because we gotta figure it out, how to sort it out. In 423-41528. This alleges that on or about December 23rd, looks like 2 days before Christmas in 2022, over a year ago. You're charged with the second-degree felony of assault on a peace officer. Let's say by kicking the person in the leg with your foot, and you knew the person was a peace officer lawfully arresting you. Then in 23 CR 2002 and 2003, these similarly allege that on or about October 19th of 2023, which would have been about 10 months later, in Jefferson County, Texas, you committed the second-degree felony of assault on a peace officer in each case by kicking one officer in the leg with your feet, and in the other case by biting.
I can't bite Judge because all my teeth have to be.
Am I gonna look? Are you gonna interrupt me?
No, sir.
We'll be here all day.
No, sir.
Don't do that. You'll have a chance to be heard here. Just don't worry. Let me speak first. That's the way the rules. This alleges that you bit the officer on the leg with your mouth, and those are two instances that look like they occurred in the same event.
Correct.
Okay, I'm looking at these two probable cause affidavits in these two events. Have you seen these?
Yes.
We got a problem, don't we?
We got a problem.
On this, you seen it?
I'm not
Okay,
giving her
on
to-
the probable cause affidavit of these last two cases, it's like they looked at a different probable cause affidavit. Because probable cause affidavit. She began kicking Officer Froman's right leg, causing him pain. However, that is what's indicated in 23 CR 2002.
Yes,
For 2003, however, this indictment alleges that the defendant bit the officer on the leg. But I'm not sure that's what this says. Listen. And kicking parents best while putting Haynes in the rap, she bit Officer Froman. She then grabbed my right hand and dug her nails into my forearm and trying to scratch me, causing me pain. That is written by Officer Mitchell.
yes.
And it says Mitchell bit Mitchell, but she didn't. This
was
says
too
it
rough.
scratched Mitchell. But she kicked Froman, which is what's alleged in the indictment. So 2003 doesn't conform with the complaint.
And we'll make, Judge, we'll amend that. We'll do it formally, or do it by motion to amend it. So it reflects what it should be, because I think what they did is. It wasn't, it's not reflecting.
No, it's not.
We see that.
No, it's not, but I don't think you can amend it.
Well, I mean, we can re-indict, and I don't mind, proceeding just on,
All right.
as, that's obviously there's an error in that. However, the one that remains, kicking two from
You got two other cases though.
same,
None of these are
Same behavior.
good, and they all constitute second degree felonies where you can be sentenced up to 20 years in prison in each case. So you're looking at up to 60 years in prison because police officers, we don't assault peace officers, they're acting, in fact, they're acting for you, they're trying to help you. And that's what's ironic about some of these cases. So, today, what do? Reset this. Because y'all gotta redo this, I guess. And I'm gonna reset it for 4 weeks. Unless y'all tell me.
3 months.
I'm gonna say one more time. Don't interrupt me. You'll get a chance to speak. You're just getting in deeper trouble. Because when this lady can't do her job as a court reporter because more than one person is speaking, the law states she's really the most important thing, because if somebody interferes with her ability to type everything that's going on, which she cannot do when people interrupt, because she can do 350 words a minute, which I think is a world record, but she can't type when several people are speaking. Don't interrupt, everybody gets a chance. But if she can't do her job, everybody involved gets in trouble, including you and lawyers. So do not get everybody in trouble. You're in enough trouble. You're looking at up to 60 years in prison here, unless you navigate through this thing with good advice that he can give. So I'm going to reset this for 4 weeks, and but we've got 2 separate events where similar misconduct. See what we can do, or else we'll go to trial on each one and try 3 of them, and that's a way to do it. But maybe something can get resolved. How long have you been in jail now?
In jail for 3 months, but I'm a trustee, so I have 345 days. 3 months.
Okay, that's all I want is day for day, how much?
90 days.
90. Okay, I'm gonna reset this 4 weeks and see if y'all can resolve the indictment and any other method, and then we'll move forward, okay?
Thank you.
Okay, thank you, I'll reset that, thank you. And Mr. Green probably has more, I think Mr. Green has more indictments than anyone on my docket historically ever. Which is, I guess, for some notoriety, but. Okay, on this one, who's on this one?
That's Sonny.
Which case carries with it the most punishment?
Judge, there's been a couple of times where we've gone through this, and one of these cases is mislabeled.
Okay,
He has a failure to register as a sex offender. One of the theft state jails is actually a registration offense. And that and the assault public servants carry the highest punishment.
over here.
Yes, sir.
God bless you.
I want to speak to you, sir, because
Yeah,
last time
Henry.
you fired him like
It's-
5 times going in the field.
It's good to see you.
Yes, sir.
again. All right. We've got 22 cases here.
Yes, sir.
Okay, we gotta take them.
So, yes, sir. Go my bad. Go ahead, Judge. My bad. Go ahead. Yes, sir.
Davis, yeah.
Yes, sir.
So we gotta be deliberate here.
Yes, sir.
That's a lot. And like like I've said before, this is the most cases any defendant has ever had before me since I've been here for almost 20 years,
Yes, sir.
which is not the kind of prize you want to win,
Right.
So you've got, it's hard enough to fix one. Now you've got 22, and those need to be deliberate, responsibly dealt with.
Yes, sir.
All right. You've got a bunch of thefts here, and then evading arrest, another theft.
I never debated with her, sir. Go my bad.
This
sir.
is what we're charged with.
Yes, sir. Yes,
This
sir.
is in the trial.
Yes, sir.
It's in the debate.
Yes, sir.
Okay. Then two assaults of public servants. I guess those are gonna be the more serious.
Then I got beat, I'm the one got beat up. I had two black guys in the factory.
You know what?
I-
We're
I-
gonna put you in timeout like we
Oh, yes, sir.
had to when we were
Yes, I'm sorry.
kindergarten.
Yes, I'm sorry. I'm sorry, sir, I'm sorry.
Don't do that.
Yes, I'm sorry.
Judge, let me correct the one that is mislabeled. It's cause number 41332. That
Yeah.
is not a state jail theft,
What is it?
failure to register,
As what?
sex offender.
Okay, the most serious cases, I guess, are assault to public servant.
Along with
Is that
the
the-
registration offense. Those
And
are all
what's the degree punishment for those?
third.
They're third degrees. Okay, so you got, oh boy,
That's Miss Bob.
Miss Bob, my God, God bless her.
Feel the spirit.
Yeah.
Feeling something. Yeah, that's Miss Bob. I'll add some things. for the-
Did you, was she doing that? Hey, Henry, was she doing that earlier?
No, sir.
No. Wow. And she's got to run out of gas soon. That, you just lose your voice.
Hey,
Got
Bill,
more
I-
counts.
And I got the side officer, I got him, he retired, I got him suspended for 30 days for him not feeding me, March 2022. I got the grievance number and everything. I'm
Last
trying to
year?
give it to him, I'm trying to give it to him so he can pull the grievance.
Wait, last year?
Yes, sir, 2022, and then.
Oh, that's 2 years ago.
Yes, and then March, then, June the 6th, I come in from rent, he tore off a commissary myself. So I went to the front in the day room, I said, "Doc," I said, "Please call rank, sir." He ain't call rank, he picked me up, hit me out, the moment say hit me over 100 times in the face, him and Biggs. Lieutenant Ford had to come pull the box.
What happened? Did they send you to the hospital?
No, sir, I had two black guys that fractured jaw though.
Hmm.
I had two black guys.
Fractured jaw?
Yes, sir, my jaw was fractured.
Did it like heal itself over
Yes,
time?
sir, yes, it's not, if I know if I open my mouth over 30 seconds, while I can't get pop out of place, possibly. Nigga talk about I ain't even saw nobody. I beat his arm because he been out first.
Well,
He been out with right.
here's the deal,
Yes,
is
sir.
that the grand jury
Yes, sir.
indicted you.
Yes, sir.
And they heard some evidence.
Yes, sir.
On the other side of the coin, are you, right now, are you guilty or not guilty? Not guilty
Right, not
because of the presumption of innocence.
Right.
Okay,
I call it.
you got that going
episode.
for you.
Yes, sir. Criminal
But
episode.
let me look at these assaults here, what we're looking at, because they seem to be the most serious. What,
Got some codes on here.
Henry, where, are you still living on 15th?
Yes, sir. I got some codes on here, some legal work. It's clean. Okay. Thank you, my brother. Let's see.
Oh, you got your notes?
Yes,
All
bro.
right, I was wondering, who wants any chances?
Go check that out. I got, music combat, that's what I call music combat. And I got cases, my log numbers on there, I got dumped on by the mouth.
You bit, this says you bit an officer on the arm.
Yeah, he hit me now, he hit me, I was handcuffed, sir. He hit me now until my leg go to the fence. I jumped up when the yank go up off the ground, I was sitting down.
The other one here is you kicked the officer in the legs and the groin.
No, that's a lie.
That's gotta sting.
That's a lie, sir, that's a lie, I never kicked him, that's a lie. He trying to cover that Jones, he said I kicked, I
Yeah.
never kicked him. They hit me over in the cell over 100 times, I had two black eyes and a fractured jaw. And I told mom and dad to call you to see if I turned the fast, showing you the picture that Lieutenant Wolf posted, took a picture of me and sent to a turn the fast, and turn the fast part, sent the picture to you. And then that go
Okay,
by the rules.
here's what you, how long have you been in jail now?
21 months this month, sir.
21.
21 I got cancer, everything, sir.
Yeah.
I got cancer. My dad fight prospect. My dad had many strokes. Never been locked up. He had many strokes, and my dad fight prospect cancer. So if I somebody else, if I come back, you can.
How are they treating you on the prostate cancer? What are they giving you?
No, my dad fight prospect cancer. I'm
Oh,
telling you,
it's your dad.
if I come back for you, let me go home today, sir. If I come back for you, give me 25 life. Now sign it right now. I agree. I'll take 25 life. I come back for
Well,
you.
it's not the, you can't be making deals with me. You gotta go through the
I'm not gonna
process.
come back. I'm telling you, I got my life. I'm gonna go back. I'm gonna take advantage of the Joe Biden rent and go to school. My
So,
son,
how do we want to deal with Henry so that he can move on with his life one day?
Judge,
He's been found competent, I'm pretty sure, Judge.
That's a while back.
but Judge, I did give Mr. Green the offer of the 5 years TDCJ on to solid public services.
Well, how much does he,
But he's saying that he won't.
how much does he have credit for?
He did tell me he would take time served. Did he tell me he would take time served?
you take time, sir, yes, sir, time,
How much?
I'm not guilty.
406 days. How long it's been shut down.
What was the
He
offer?
did tell me he would take time served on all
What
these
one?
cases.
What was the offer?
Oh, I'm sorry, Judge.
Yeah, nobody told me.
I'm sorry, the offer in this case that I gave to him was on the death cases, probation 2/5 plus restitution to be determined in the probation.
Where are you gonna, if you were released, where are you gonna work so that you can pay some of this loss back?
My brother, president of the Port Authority, sir. My brother, president, and he been working there since like 9/5. My brother, President Benjamin Green, you could bump Facebook, my other brother.
How much
Juan.
would he pay you?
I make $20 an hour, and plus I got a 7 on the way. I had a simple part of the rest. Look at it, I got 2 in my head. You see that right there in the back of my head, sir? That's
Oh, yeah.
cancer.
Did
That tumor's in
Mr.
my-
Kimler do
I
that?
got
to you?
tumors in my head, my leg, and my chest, sir. Oh, Jesus Christ. I need to get by. I went to Galveston when I got out last time to the emergency room. I went back, they told me if I with an appointment, and they probably got me biopsy so I could find what kind of cancer I have, so I can
And
fight
how did you get hurt?
cancer. I had to fall, but my
You
lawyer,
fell
yes,
while
sir.
you were at work?
No, sir, at the restaurant, my lawyer took me for $1,000,000. And that been to that March 2021, 17. March
So
17,
where did you fall?
at a restaurant in Port Arthur.
So what did you slip on? Did you slip on something?
It was the water, the floor was
Oh.
wet and it was greasy. I was slipping field. I tried to grab a trash can. I slipping field. I fell on my back, hit my head every time. Hard as something.
So what's the offer that y'all?
I'm sorry, Judge.
Yeah, let's get back to that. See, practically, what was it?
Judge, it's the issue is that we've offered TDC time on
Well,
some of his
what-
higher charges. However, there would be a consecutive probation where he would be put on probation after he were released and
So he
have
could
to
pay
pay
the-
his restitution.
Restitution?
Because it's a mixed bag of everything and we've got to,
Well, so,
accomplish
no,
two different.
what's the flat time?
Flat time was 5 years TDCJ, and he told me he wouldn't take that on.
Well, he's almost done it now, hasn't he? I mean,
Five
He's almost,
Quite close.
he's almost fulfilled that. And then we could get him, I don't know how, you may have to spend a little more time, but that's not for us to decide, but it sounds like you're eligible probably toward parole. Then the other agreement that they would put you on probation for a period of time so that you can get the money to pay back for restitution, working or whatever it is you're gonna be able to get them. And on cases like that, once people pay the restitution, I terminate the probation.
Yes, sir.
Once we get the restitution, there's no reason to keep you on probation.
I pay that right. I take probation, pay it off. So my lawyer told me so I get out. I call him on the phone.
Well, you don't have the money with you right now.
He report savings from me at that. He can write my check to me. It's supposed to be
Why don't you-
$50,000. Yes, sir.
Are these affirmative, there are no affirmative findings on these assault on peace officers, so he gets paroled in a quarter of his time, right, on
Correct. Judge.
5 years, a quarter of a time.
He's eligible.
He's
He's eligible when it's good time, it's flat time, equal 25%. That's just eligible.
And he's been 22 months?
He was probably already.
See, he'd probably be-
He'd already be eligible.
You need to think about that. You'd probably be eligible for release on those, then put you on probation, get you out.
I'm not
And
guilty, sir.
once you pay, well, that's important. Yeah, you'd have to admit that. You can't do it. All right.
They beat me up. And then I got, he retaliated on me. That's a felony. On also
I
retaliated on
don't see
him,
that.
man. It's a felony, he retaliated on me. I got the grievance number right here, look.
No, you don't, I don't have that. That's not filed against you.
Listen, I got the grievance number right here. I got John suspended. This is the
Hey,
grievance number. I
hold
tried
on.
to get him to pull the grievance
Hold on,
months
Tex.
ago. He ain't doing that
Hold on.
for me, man.
That's not on here. That's not what you have. That's not been indicted. You hadn't been indicted for that.
Assault officer, he have been indicted for 2 assault
Two
officers.
assaults.
And that's John,
But
John's one assault.
You were talking about something else.
I'm talking about Jones. He assaulted me that day. I got him
All right.
suspended. for not feeding me.
So-
He's saying
He
he
retaliated.
was retaliated on.
Oh, he was
Yeah.
the victim.
Yeah, I'm the victim. I'm a victim of retaliation.
Well,
And
have they filed that on somebody?
my wrist, man. I was handcuffed for 14 hours back then
Oh,
in March 2019.
okay.
And the rap for 14 hours.
Here, we're not getting much done now.
Yes, sir.
Okay, I understand things. Here's what we're gonna do is the assaults on public servants, we'll just set those for trial. That's what we have to do. If we can't work it out, we'll get these things as soon as possible, and the others are just going to have to wait. But we'll get it for trial, okay?
Yes,
That's all
sir.
we can do.
Yes, sir. Check how big your new lawyer.
Yeah, no, Langston Adams is a very fine lawyer.
You fired him like
You can hire anybody you want.
you fired him 5 times ago. You fired him literally 5
I
times
didn't
ago.
fire him.
He-
No,
Look at the paperwork. You fired him 5, you know this. It was here 5.
I'm sorry.
You fired like that, in fact, this is the Kansas, I told you last
The
time.
way it works is that once you have an appointed lawyer, the indigent commission says that you have to keep that lawyer unless good cause is shown to replace him. And Mr. Adams is a very vigorous advocate for his clients.
Hey,
I
sir.
know that.
You can look at the paperwork, 5 times, I looked for you, I see you can jot down your paperwork, you told me you can hire me a new lawyer. You say you.
I'm not gonna hire anybody
And this
for
came
it.
out your mouth, you said you're gonna hire me a new lawyer, and I'll be back in your court, I'll be back in your court faster.
Why would I do that?
Because we were getting along. We not getting along, he not doing nothing for me, man.
Just because you don't
He
get
not doing
along.
nothing for me. In fact, this is the council.
Look, this isn't a date
I know,
and you're not married to somebody.
It's in fact.
This isn't a divorce.
I feel like he not doing nothing for me, he not doing nothing for me.
I know him to be very vigorous advocate. But you're in jail when he's doing the work for you.
He didn't even let me see the tape, he didn't even let me see the side out the tape. He didn't even see the side out the tape.
His mama and dad were in my office and we watched the video of the incident and I.
Well, he wasn't there because he was in jail.
Yeah, he was,
Exactly.
Okay.
but the mom
Well-
and dad was in my office.
Hey, let me see, why you let me see? Why you let me do the camera? Why you let me do the tape on? You ain't doing nothing for me, man.
All right. Well, I'm gonna set these assaults for trial, okay, and get those as soon as possible. That is all, Henry.
He just told me he wanna be off my case before I came in here.
Come on, partner.
He just told me he gonna be off my tape.
He may not enjoy representing you, but that's not the test. You can hire anybody you want.
I got one of the best.
What do you- And you've got the other one. Yeah, yeah.
Langston has the.
All right.
one cases.
What else do you have here?
Thank you.